we thought this was a good starting point, the bickering employees. I have two direct reports, Georgie and Kat. They're both team leaders in a retail environment. Now, they work together and they seem to be good friends, but they've both complained about the other. The complaints are identical. They've both complained that the other's bossy and unpleasant, that the other one is lazy and shirks responsibility, and the other one bullies their staff. I tried a couple of times to ask them if they think they're contributing, but they both say it's the other one. They're both threatening to leave unless something is done about the other. Now, I've tried raising it in a group. However, when all three of us are together, there's no evidence of a problem. They seem to get along very well and deny that there's a problem. So, any thoughts? Any thoughts from Helen? I'm sure Helen's got opinions.
There'll be lots of thoughts from Helen, but we are going to try and get other people to speak if you want to share any experiences or ask any questions, because I know a lot of you are involved in managing businesses, HR, etc., where you've probably encountered a lot of these type of situations. Does anyone have any, well, I'll ask a question if anyone is going to probably answer it. Does anyone have any thoughts about whether this situation that Brian just described should be dealt with in a formal way, as a formal grievance?
First thing I'd want to do is give me facts, not emotion. I'd be asking, can you give me a fact to demonstrate that the person has been inappropriate or supposing bullying? You know, give me the time, date, what happened, was there anybody? So I'd be looking for factual information. And I'd also ask them, are they wanting to make a formal complaint? And if they do, this would be the process.
Yep.
Quite often, as soon as I do that, they go, no, I don't want to.
Yep.
You know, and they're very, what's the word I'm looking for? Vague.
Yep.
On being able to come up with factual information that helps.
Absolutely, and I think, you know, bickering employees can be a real issue to productivity and a real issue to work health and safety. So it actually needs to be dealt with. But I entirely agree that you don't allow it to just continue. In the grievance talks about attempting to have mediation, attempting to talk and get them to realise what the person have they contributed, etc. And whilst in a very, very short term there can be scope for a flexible approach, I'm very much like you in this type of situation. I think you need to get formal, and you need to get formal quickly. You need, as well, apart from anything else, I find that if you force the issue of formal grievance, it can have what I refer to technically as the put up or shut up effect, which is incredibly important, because you then get into a situation where if you're not going ahead with a formal grievance, I don't want to hear about it ever again. Which I know sounds firm, but it really is the only way. But there is another issue that I think, not this one's, you know, obviously, you know, general, and we've taken out sort of some details, etc. But one of the issues is there is also, in my opinion, a line where it gets out of the employee's choice as to whether to make a formal grievance, and you investigate regardless. And to me, that line, a lot of people think when they come to us and say, well, she's not prepared to. She or he is not prepared to formalise the grievance, but it's this issue. And what I'll say is, you know, is it affecting productivity? You're worried about the situation. It doesn't have to be a formal grievance. If this is affecting your workplace, you can deal with it and you can investigate it. And that's really important and, you know, liberating, although frightening for a manager to know, because it's a if there's an issue that you think is affecting productivity, safety, etc., you as the manager or HR owner, whatever your position, if you're in charge of that situation, you have a right and an obligation to investigate exactly what's going on factually, not not feelings, emotions, I don't like them, just factually what is, because often you have to say, you don't have to like them.
However, if the person can't give you facts, you can't go back to the other person and say, on this day this happened. So to investigate, it ties your hand.
And then it becomes I don't want to hear about this ever again. If you know what I mean.
Okay.
But I know that sounds
But
awful.
it could be, he's the AP provider. I suggest that you seek some assistance to get some guidance to work through why are you feeling this way.
So it may not be a formal investigation, but you're still dealing with the situation, because if you've concluded on the basis of your information that the issue is perhaps someone's
Lack of confidence.
like
or,
was emotional, going through difficulties at home,
Yep.
whatever,
or they
then you
just
still
don't
have
like each other.
obligations. But the number of times you sit down in these situations and say, look, I know you don't like each other, I don't care that you don't like each other. That is just...
But even sometimes, I mean, in terms of an investigation and what that process requires, you could have a situation where, of course, you would interview the person that's initially made some sort of complaint and then interview the respondent as such. But there might be other relevant people. You know, if it's an event that took place in the workplace, like a physical altercation, you could interview other people. Yeah, often that isn't the case, and certainly here with bickering employees, maybe you're not going to have any witnesses as such, but certainly interviewing other people, looking at other material like emails.
Or if they've said, as I think they have, that they've seen the other one bully their
Yes.
staff,
Yeah.
you then really do have to ask their staff,
Exactly.
you know, which
So-
is difficult.
Yeah, going through that process of interviewing, obviously the person complaining, the person that's responding. In this case, you've got two people complaining, so interviewing them both, interviewing other people that might have been working with them when you weren't there, because I think this scenario, it's sort of all happening when their manager's not there. And then really gathering as much information as possible so you're in a position to investigate properly, look at all the facts, and then make a decision about, well, is this a valid complaint or not, or is this something that I need to say to the person, look, I've considered it and I really don't think that's a valid issue, you need to move on from it. And obviously there's a whole heap of things that need to be kept in mind when you're investigating, things like procedural fairness, confidentiality. I've actually put in the packages a whole list of things because I think it's probably too long to go through tonight, and a flow chart of this is the sort of steps that you should take just generally in an investigation, because it's going to depend on the situation. But yeah, obviously confidentiality is really important. You don't want people colluding about different things, even unintentionally. And procedural fairness, you know, making sure that you're giving each person an opportunity to talk properly, putting the allegations to the person that's being blamed and getting their response. So
I think one of the most difficult things a manager or director of a company ever faces, one of them is that situation when someone says something but won't give details, because it's then in your kind of corporate knowledge, and you really have to do something, even to the point of giving a direction to someone. You have to tell me. Because there have been many cases where there's a build-up, things are said to HR off the record, and then 2 or 3 years later, or 2 or 3 months later, it's escalated, and something really quite significant has happened that's caused psychiatric damage or etc. So one of the things that I often say, and this is really hard, but to say to people, when you're in a management position, you're HR, there's no such thing as off the record. Absolutely no such thing as off the record, because once you know about it, you have to deal with it. And if you are genuinely concerned about it, you don't think it's just a whinging, you're genuinely concerned about the person's not giving you details, there does come a time where you have to give them a direction. You have to tell me. Because you're not putting in a formal grievance, I'm looking at a workplace situation and you have to tell me. And I know it all sounds a little brutal, but down the track, if you end up in a situation where there's been something really very significant has happened, and unfortunately we've seen a lot of those to an employee, etc., and it comes out that even informally you knew about or had concerns and nothing was done, it can pose, unfortunately, a bit of a legal risk.
And also an important consideration is, even if the employee says that they don't want to take it, further and they don't want to make something formal, you have to consider the effect that it might have on the rest of the organisation. What culture are you trying to furnish within the company? What effect is it going to have on everyone else within the organisation? Are they going to see these two employees bickering and accept that that's normal practice? Everyone's worked with, at some point in their careers, I assume, has worked with an employee that's frustrating or annoying or you don't really want to work with. I mean, and unfortunately it is kind
Just
of
elaborate,
Particularly in a small firm like where I work at the moment is quite small, and we recently had someone, I mean, it was just the way she spoke to another individual, but I had probably 4 out of 8 staff members coming to me saying, we're uncomfortable by how this person speaks to another. So in a small environment, it's really noticeable. And it does, it poisons the culture.
Exactly, and it has an effect on people wanting to come to work. Are they going to, are they going to be sick more often? Are they, are they going to have low morale, low productivity because they don't want to be at work, they don't want to deal with their colleagues? And it comes a point when an employer will have to decide, well, for the best, interests of the company, I'm going to have to investigate this and take action because I don't want this to become a part of our culture. I don't want other employees to take cues from this. Regardless of what the employee actually wants out of it. So
I think the word threatening to leave means they have to take accountability, because if they're offering any sort of threat of that nature, then I'd be quite comfortable saying to them, these words that you're threatening, you're going to leave, means that you have to take accountability and we have to formally report this.
For every, I don't know, we'd never know statistically, but there's people that threaten to leave, and then there's people that just leave and don't threaten to leave and don't. Some might bring legal action afterwards, but most won't. You just lost them, and you're never going to know. So I do think it's a really hard one, but I do think taking cues and being a very aware manager about what's going on is better.
Talking of culture, I think probably a good time to move on to the next one. Because this is the opposite problem, the culture of affection. Now, very interesting. When I searched inappropriate touching at work on Google, I couldn't find a picture of a woman touching a man. So I know if they're buying the same stereotype, but I think that's interesting because this one says, I'm the director of a creative business. The layout and lighting of our workspace has been particularly designed to enhance our sense of well-being. We're a close-knit team and have known and worked with each other for many years. One of my fellow directors jokes around a lot and is physically affectionate with all of her staff. A new employee mentioned in their 1-month probationary review that the director's conduct makes him nervous and is causing him stress.
Yeah, and I think in this case it's a sort of difficult situation because it's a director. It's not, someone that you're necessarily in charge of. If there's 2 directors of the company and you're being told something about another director, it's a very difficult sort of decision for you to do. And I think also, as you were saying before, you need to probably firstly try and figure out some facts. What one employee says is affection, might be a pat on the shoulder, it might be hugging people or kissing people, who knows. And then from there determine, is it something that maybe the director can just sit down one-on-one with the other director and say, look, this new employee brought it up, what's happening? Or is it something that does need to be investigated depending on the circumstances? But I guess a really important thing here with the 2 directors is the importance of showing impartiality if there was some sort of investigation. Can one director actually impartially investigate another or not? Will the employee be very suspicious of that? I would think they probably would, and think that they're just going to cover it up and act in the company's best interest. So it's, really ensuring if an investigation does take place in a company that it's seen to be impartial, but it also is impartial, whether you're getting someone from another team to come in and look at it if you're a bigger company, or if you've got an HR manager, that's typically the first place to turn to, or, if required, getting someone external to do it is sometimes the better option for smaller places. So I think they are some of the key things that this scenario throws up.
it's also interesting touching on impartiality and the fact there was actually a case a few years ago in Victoria where a male employee made allegations against his female manager that she was inappropriately and intimately hugging him on regular occasions, despite him having told her that it was inappropriate, it made him uncomfortable. He also alleged that she regularly discussed her sex life in front of him and that made him uncomfortable. He brought an action against the employer for sexual harassment, that they were liable for it. What was interesting in this case was that the employer actually tried to claim that the culture within the organisation kind of was that everyone hugged one another and that they were overly affectionate, that they did discuss their sex lives. It's very strange.
I think that's unique.
And everyone was just within it, just expected that that was normal, except this apparent one employee who was uncomfortable. The employer tried to say, well, we had sexual harassment and bullying policies in place. What more could we possibly have done? And it came down to that the employer should have been aware that not everyone's going to consent to this sort of conduct, and that even if you've got a policy in place, you're still going to have to take action when people say, you know, I'm uncomfortable. Apparently a lot of employees within the organisation had seen that the employee was uncomfortable and had told her, you know, don't hug me anymore, don't touch me, and no one did anything. At the end of the day, the company was liable. The payout was quite minimal because there were other contributing factors as well. But it is something to keep in mind that the culture of the organisation doesn't, you know, condone sexual harassment or bullying, despite what might
Did you have a
be
question?
accepted.
I think you probably covered it off. I was just going to say, obviously you investigate, but even if, like you said, even if it is just the normal culture and it's making somebody uncomfortable, obviously still something needs to be done about it. So
Exactly, and I think that's where new employees can often actually give a lot of insight to people, because they've obviously come from a different culture and they can be a bit of a test or a barometer for you if you sit down, you know, have a probationary review with them and they bring up something that you think, oh, I hadn't really noticed that, or oh, maybe I need to look into that issue. So I think that in this case where it is a new employee, you know, you obviously need to test it and maybe talk to the other director, but maybe there is an issue. Certainly investigations I've carried out where people, you know, you ask them to explain some sort of behaviour and they say, oh, that's just Joe. Joe's just like that. Everyone knows Joe's like that, and we all just accept it. And it's sort of, Joe's been here for 20 years and he's like that. So I think it is important to sometimes listen to those newer employees and take some of the insights that they offer.
Is there a way, Lucian, can I ask, how do you ascertain, because these types of things are very subjective, you know, physical contact, is there a sort of objective method of ascertaining what's actually happened here? Is this guy just got a bit of a weirdness about him, or is the director, you know, is he a bit oversensitive to just, you know?
Yeah.
I don't think you should have to be hugged at work.
No.
At myself, but you know, some people might be happy to be, but
If it is hugging, this just says physical affection. So I think,
that's just my view. That's
You
not an
find
objective
out
standard.
exactly the details
yeah,
of the contact.
and you have to be culturally sensitive as well. You know, you might have people from different backgrounds with different acceptable and non-acceptable things that you have to take into consideration as well.
Because we have to remember, like the old days. For those of us that remember the old days.
It's totally different.
I'm sure we have a good story.
But I mean, the old days, it was a shock, you know, when people said, well, we have to get rid of the topless women because, you know, around the...
Stuck up around the office.
Stuck around the office, doing the pictures of topless women stuck up around the male-dominated... and it had to be explained to people because it makes some people uncomfortable. And if you don't deal with that, you are excluding from... This is not a group of friends. This is not a family. This is where you come to earn your living. So it's not fair for people to be excluded because they just feel uncomfortable about some certain issues. So it is quite important to, as Lucienne said, in my opinion, that sort of, oh, that's just the way the person is.
Where do you draw the line? I mean, you say, as you say, you find hugging inappropriate in the workplace. But yeah, some people just touch you fairly, and yes, you can say I don't like it, and if they persist, then you probably have a course of action and take it further. But some people can be oversensitive,
Absolutely.
Is there a point where you say you're being unreasonable?
Absolutely, and I think that that's one of the things you have to really assess up front when you, because often an investigation is necessary, but often an investigation can be worse than the original problem. It can cause more problems. So there's definitely a need for a judgment and discussion and touching in with someone. Is this, is it a touch on the shoulder, etc. One of the areas that I think is really hard in this sort of hostile work environment situation is, I think in the case Alicia talked about was referred to, this discussion of people's sex life.
Because so often investigated.
Some people just do it all the time and they talk and they're friends and, I was about to say something ageist, but I was going to say some of the some young people who might be dating, they're talking amongst each other about their love life, sex life, etc. When does that get to the line? You know what I mean? It's really hard, and the line is very different. There could be cultural issues. It's really different, and I think when something like that comes up, and it's one of the best things that a manager or HR that's confronted with it can do is just talk to the person, and if they stop it, then just leave it. If you know what I mean, just talk to the offender, using the word very, because everyone's different. And many, many people, the first time it says he doesn't like you touching his shoulder, he doesn't like you talking about your sex life, the first time you say it, the vast majority of people will never do it again, in my opinion.
The next one, if anyone's happy to move on, it's about a breach of confidentiality. This is a bit more about the formalities. Simon's being investigated for bullying and harassing, but he is telling people about it during the investigation, and he's recording some of the interviews and investigators in case he needs proof later down the track. How do you handle that situation? Do you keep going with the investigation that's already commenced, or do you just not worry about the additional allegations? Or should we address this as part of the investigation itself?
It's quite topical with our Vice President of the Fair Work Commission indicating that he records conversations. But anyway,
this scenario probably came from him.
Who knows? So has anyone had this happen to them in the workplace if they've been carrying out some sort of informal or formal investigation and everyone's talking about it behind everyone else's back? I know I've seen it a couple of times.
And we've had a lot of people come to us and say, I've recorded it all. And we have to say, it's illegal, you'll never be able to use that, don't tell anyone you've done it,
What about when the person says, I wish to record, I'll come to this meeting, but I wish to be recorded?
I would advise you to say it can't be recorded and you're required to attend the meeting as part of your role.
It depends. For most people, I would say that. I've done a few where the person's come and said, I'm going to record it because they haven't got a support person, say, I'm there with the manager. And I'm like, okay. Because I know that we're going to do it right and I want the meeting to happen. But it can be difficult. But if you're happy for it to occur, I wouldn't.
We've allowed it.
Yeah, I mean, I don't mind having a record, but it can be,
I've had
It's a
some
difficult issue.
HR managers that open the meeting by saying, just to let you know, this conversation is not allowed to be recorded because they are so worried about people with iPhones and whatever just coming along putting their phone on the table.
And if you know for sure, and that's the thing that I usually say is, you can record it, but you are only, because it's confidential, to use it for this purpose. And it will be, because if we find it on the internet, there will be consequences. Because that's my main concern with the recording, as to where it'll end up. Not that they have a record, because I don't mind them having a record. But it can end up around the office.
Is there any original person that might have passed it on gets in trouble, or the person that
anyone in
came down the track might have actually put it on the internet?
Well, usually, often it's not going to be the person that puts it, but often, and this is something that comes up a lot, is that if you're not careful in an investigation, the support person, family members who are outraged without necessarily knowing what's going on are the ones that often breach the confidentiality and do the stuff. So that to me is the main danger. And then if a family member has grabbed the recording and whacked it on YouTube, you can't actually do something with the staff member because they're only responsible for their actions.
But I'd suggest best. I mean, initially, if you are investigating something, obviously telling everyone it's confidential when you sit down with them, potentially putting it in writing as well. In extreme cases, you know, if someone you know is the office gossiper, get them to sign a confidentiality agreement that they will not go and talk to other people about it, particularly if it's a big investigation. So they're the sorts of things, you know, also if you're really concerned, saying if you do breach this, then there could be disciplinary action taken.
Could I say, if you're the office gossiper, and we've had to do this quite a bit with that, if you decide there's an office gossiper involved, so you need the confidential agreement, do it to everyone. Don't just the ones, do it to there, because,
Assuming everyone in the office.
everyone who's investigated, who's speaking then. So if you decide we have to go to that step, then everyone's going to be treated the same.
But obviously it's really important. I mean, as I said earlier, people colluding, whether it's intentional or not, they're just having a chat about it because it's the thing happening that day, procedural fairness, you know, victimization, whether again that's intentional or not, because everyone's standing talking about such and such behind their back and then someone decides to confront them about it. So it is really important to make it clear at the outset and even throughout reiterating it, just to make sure that it is all sort of kept out of the workplace and kept to the investigation.
It almost never works. Like, that's why I say you've got to try and, you know, make sure that it really does need to be investigated before you investigate, because it's just, people just talk. It's really difficult. Anyway.
Can you correct?
So would you interview, sorry, I was just going to say, in this situation, presuming all those things that happened at the beginning about confidentiality, etc., I would think you would expand the terms of reference for that investigation to include this, particularly when he said that he's going to get paid back from complaints. Because
Absolutely.
what better evidence for the original complaint? What would think? But anyway,
You absolutely would. Exactly. You would expand the terms, and this also highlights why you need to do it. You need to do it properly. You need to do it reasonably quickly. One of the worst things that go wrong in investigations is they drag on forever. So you need to do, I would definitely expand the terms. Again, procedural fairness is required, so you might re-interview people, etc. But I would definitely.
Yeah. Interestingly, there was a case a couple of years ago that came up with a similar sort of thing. A HR manager made a complaint against the CEO that he was bullying her. They commenced an investigation, and as part of that investigation, they looked at the emails between the two parties, and additional allegations came up that she was passing confidential information to a competitor, and also that she had been discussing the matter with one of her witnesses that she had nominated. She had been telling the other employee what her allegation and complaint was, what she had said before they had been interviewed by the investigator.
She did by email.
It's always surprising what people do when they're working
By email.
So emails if you're investigating.
It's quite horrifying when you go back through people's emails. Anyway.
Starting up their own businesses, emailing about it, all sorts of things.
Yeah. So the investigation was broadened to include the extra allegations that she'd been passing information on and she had breached confidentiality. As a result of those allegations that were found against her, they terminated her employment. The employee then brought an adverse action case against them, claiming that she had been terminated because she'd made a complaint. Ultimately, the court found that no, the allegations had been proven against her and they were legitimate. They weren't in response to her complaint. So her case was dismissed, and it really does show the importance of investigating the extra allegations that might come up, and raising them with the employee, because they might be legitimate and they're not necessarily going to be in response to it.
So he might have been bullying her for real, but he got away with it.
I don't know what the ultimate result was of the complaint, but yeah, because she had engaged in passing confidential information on her.
But that is one thing you often have to be aware of. Sorry. Someone going to say something?
No.
I was going to say, one of the things you often have to be aware of when you face these situations is you might have proven the breach of confidentiality and you're going to terminate, but because you need to work out what's going on, say with your bullying CEO, you suspend them but don't terminate them until it's over because you still need them to get information. So that's, you know, you can end up in, I don't know what happened in that case, but you can end up with one terminated for breach of confidentiality and the other terminated for bullying.
Or that they were having an affair. And then broken up. You know what happened?
It all came out there.
Did the breach of confidentiality and all that sort of thing, did that come up via the looking at the emails for the bullying?
Yes. So they
And
were
they
trying.
were allowed to be used?
Yeah, they were trying to look at the relationship between the HR manager and the CEO, and apparently there were a lot of emails between the parties which were inappropriate. And as a result of looking at those emails, they found the allegations against her. So it's unfortunate for her, I suppose.
And I think this is just a completely side note, but you know, you've got all these workplace surveillance apps, etc., which, you know, if you don't have a notification, you can't go and look at people on their Gmail or keystroke what they've been looking on the computer. But you can always look at their workplace email. You, as the employer, own that, and you can always do it, and it always happens. So just as a general thing, anything sensitive, don't email.
So if you have allegations of bullying and the person leaves employment for whatever reason, should you still continue on with the investigation because it's a workplace problem?
I think depending on what the allegations are, if they're quite serious, I would continue on with it anyway. And depending obviously how much information that you've gathered before they leave. But sometimes it would be appropriate to end it. I mean, if it's one instance of one person and you're sort of thinking, oh, I'm not really sure if this is some other issue going on and they've just had a general conflict, then maybe you wouldn't continue. It's really depending on the circumstances.
Are you concerned? Is there something in it that, if true, if proven, you think is going to affect, you know, the work health and safety of other people? That's what to me, it's the same kind of test as when the person's not doing the formal grievance we talked about earlier. Is it just two people being petty and can't go along, or is there something in that could genuinely, in your judgment, people get it wrong all the time. It's really hard. We're dealing with human beings, but if there's a real concern that, if proven, this could affect work health and safety, you've got to proceed.
What about the worker that was dismissed? Does she have any right of action if that allegation was subsequent? I mean, I'm thinking you could argue the IL did this because I was being bullied.
It could be constructive dismissal. It could.
But if you're in the middle of investigating it and doing it properly, they would have a hard time trying to show it's constructive dismissal. You know, you'd put in place, maybe if it was their manager, they were reporting to someone else temporarily, so you was trying to stop anything that was potentially happening and you were seriously looking at it and they just decided to leave. As you indicated up the back, they could still put in a workers' comp claim after they've left, but bullying actions, anything like that, you still need to be employed to put in a bullying complaint with the federal commission.
It depends how long your investigation's gone on. Again, you can't allow it to just go on forever. Though, you know, it's even, again, talking about Michael Lawler, there was an interesting thing we saw today where the president was saying to a committee that he couldn't investigate complaints about Lawler because Lawler said he was so ill that it was causing decline, which is a constant problem that you have. But that can be a real difficulty if one or both parties is saying they have a mental illness, which means they can't participate in the investigation. That can create absolute difficulties for you as a manager, because you can't leave the other one on hold, and sometimes you just have to make calls that protect the safety of all concerned and do your best, because you've always got to remember that as a manager, HR manager, you're not a court. No one expects you to hold to a standard of perfection. Absolutely not. You just got to do your best and act reasonably. And often acting reasonably, even if you get it wrong, is much better than not acting. The worst thing is to not act.
Jacob has been redeployed by our company after we were acquired by a larger organisation. During the acquisition, two senior managers sat down with Jacob and explained that, as they were aware that he had excellent sales skills, he'd be redeployed from a marketing to a sales role. Jacob agreed to the redeployment during this meeting, but now he's made a formal complaint to HR and the General Manager, claiming that he's been made redundant. He advises that he's been to the Fair Work Ombudsman and he's been advised that he should be compensated as a redundancy and then invited to apply for a new role.
So I think probably the first question is it a grievance or
Yeah.
not? Is it something that you should treat like all the other ones we've talked about, or is this really more of a typical employer dispute with the employee that potentially could go legal? I think is the initial question.
See, often it will not be a grievance. You just made a decision in terms of the workplace. Sometimes employers will put in there, say, performance management or contracts of employment provisions that sort of give an employee a capacity to have a say in relation to performance review and these type of issues, which can sometimes mean that it could be a grievance. I generally advise, do actually give them a say, to never put it in your policy or contract, because you want to give them a say just because you want a nice, effective, productive workplace. But if you put it in your policies and contracts, people think consultation's a term that a lot of people don't understand. But generally, it's not actually a grievance. So there's exceptions to that because it's not done properly. But it generally it's just a decision that's been made in terms of your contract of employment and provided your contract and policies comply with it. Usually it's not an internal grievance.
But I think typically major workplace changes like redeployment, changing shift hours, things like that can often result in grievances if they're not handled well. And people often feel like they're being targeted by their manager, or particularly if it's one person being made redundant rather than a couple of people and a company announcement as well. So I think you have to be careful about managing that process so that hopefully it doesn't end up with a
Absolutely, and that's speaking to people in those, whether it's an acquisition, change of role, etc. Communicating. People hate to be treated like widgets. They need to be, and there's a number of, even if it's whether it's an acquisition, and I've seen acquisitions where it's a sale of shares rather than the actual thing, and people say, we don't need to consult, it's not affecting what we're saying. You want to fight about the terms of the award, or if you want to realise that if you don't consult, you're going to have dysfunctional. Or they just get, a letter from someone they've never met in the business, the head of HR, and sort of like you're just expected to go along with it because you're being really respectful of the person and the fact that this is going to be quite a big change for them, and apologies that they're going to be scared. They're going to be scared, and it's so important. The number of times, if you actually put that effort in to talk to people and understand that it won't be every position won't be there, but you're going to do your best, and you've got a forum to ask questions if you need to. It will reduce the problem by about 99%. And it's not. I mean, yeah.
I mean, occasionally we'll just get a very argumentative employee that likes to have an argument and likes to think that they're a bit of a legal buff and they want to go head to head with you. So there are some exceptions.
Can I ask a question on that though? At what point does it really stop being a grievance and you need to say, this is not an internal thing, this is a cause of action against us, so go get a lawyer and sue me.
And I think that's where, the person's talking about
I never advise you to say, I've run the to say this is a job that's being offered, you'll have a few days to decide you either accept it or your employment comes to an end.
Yeah, I think it's also important that you take, when an employee comes to you, you know, I've gone to their work ombudsman, or I've got legal advice that says you're doing such and such wrong, you do take that seriously. I mean, in a lot of circumstances, the employee might be completely off the mark, but in other circumstances, they might be right, you might be doing something wrong. So it's important not to just, you know, brush it off or, you know, and conversely overreact to it, but to go and get your own advice, whether that be going to the ombudsman yourself or going and getting legal advice. Looking up the internet even, like there's so much information out there on the internet that you can usually get a general idea whether it might be specific to your circumstances, but I mean it's important to go and get your own information and just checking you've done everything under the consequences. I mean, one of the big problems with the federal ombudsman is pretty much bringing them up and tell them a scenario, if you tell them in the right way, you'll get whatever answer you would expect. And so people do have to be really careful about that. And you know, typically where I've had HR managers come and say, oh, well, let's spoken to the ombudsman and they're sort of sweating it, I just say, don't worry, they probably don't understand the picture. And certainly I'm telling you, you've done nothing wrong.
Don't hesitate to ask them. One of the things I think is don't hesitate to ask them, look, if you printed something off and you think, give it to me, I'll be very have a look at it.
Yeah.
You know, because there's nothing wrong.
And report back to them what the outcome of your own investigations are. I mean, you're also the important thing is not to overreact and then take some sort of adverse action against them to prove that they're on the right. And there's a number of court cases that have found getting legal advice is a workplace right. So going and getting their advice, you don't then make them or take disciplinary action against them because they've questioned you.
They had nothing to start with. Green and King. We had a new employee who was young, straight out of uni, and very full of new ideas. And this one's actually about me. So. He seemed really bright with a big future. The difficulty was that he was very critical of his manager and other managers in general, often publicly. He criticised computer systems, performance and evaluation systems. His own manager refused to work with him because he challenged in the team meeting the way that the manager conducted the meetings and did it publicly. We tried to mediate, but eventually realised it wasn't going to work and let him go in his probationary period. Are there any suggestions on how to manage a situation like this? We were sorry to lose him, as he was promising in ways, but interpersonal difficulties between him and his manager were overwhelming.
I think in these sort of situations, there's a tendency or a knee-jerk reaction for a lot of employers to say, we'll mediate, we'll put you in a room, we'll talk about, you know, the issues and everything will be fine after that. But there's got to be some sort of investigation or, you know, questioning before you jump into mediation as to whether that's appropriate, whether there's a legitimate claim being made, whether the personalities that are involved are conducive to mediation. And you might get, they might be completely very strong-willed and opinionated, and you put them in a room and there's just going to be more arguments. You're just going to make what was a relatively simple grievance to start with even worse by putting them in a room together. There's got to be some sort of, you know, investigation beforehand to determine whether a mediation is appropriate, and also the seriousness of the complaint. I mean, circumstances where there's been sexual harassment claims, it's not going to be appropriate to sit two people in a room. There might be power imbalances.
Just tug it out.
Tug it out and sort it out yourselves. Isn't going to work.
It's not good.
There's also, I know we're running out of time, but just with this one, there's also, and with me, there's a little bit of a question mark around the manager. You know, it's almost, is the manager feeling insecure, unsure of themselves, very defensive? It just seems like they've lost control of the situation. So I query, this is really not about grievance, it's more about performance management. Whether it was right or wrong to terminate this person in their probationary period, this manager's behaviour rings some alarm bells to me in terms of quality management. You've also got to be very aware of the risks of adverse action. For those who adverse action or general protections occurs where even in your probation period, even if you're over the unfair, the high income threshold, if you make a complaint about, it's very, very broad, it's been recently defined quite broadly by the Federal Court, about your employment, and that is just one of the reasons why your employment is terminated, say in this instance, if it just contributes, there's potentially quite significant action. Now, it's very, very difficult situation for employers because, you know, there's no doubt when we're all in a busy workplace and people are trying to be productive and meet KPIs or something, someone that is whinging all the time, it is going to be quite difficult to deal with. But be very aware that that is a problem. So that is a potential legal risk of adverse action for the termination, and also I just query the quality of this manager in terms of their ability to, you know, just find someone that's questioning them. They just have to go. That's alarm bells for me.
There was actually a case this week that was very similar to this in the Federal Circuit Court, a judge that I know Helen and I have been before, where someone working for BNP Paribas, they were like a new analyst, fresh out of uni, and a very similar thing happened in their probationary period. The manager decided it just wasn't working out. They had a lot of conflict with them. They sat down with them and said, you know, not happy with the performance, but ultimately decided, okay, well, maybe we'll extend your probationary period. The green and keen person in this situation then made a complaint about the manager and was subsequently terminated. And he brought an adverse action case. And ultimately it was found that Paribas had taken adverse action. Yes, there were performance issues. The judge agreed that this guy was a smart ass. That was one of the reasons they were getting rid of him, but he also said one of the reasons was his complaint. So in that situation, I think I would probably advise, you know, you should have looked at the complaint. You know, you probably could have done that pretty quickly, to be fair. And then, you know, if you still weren't happy with performance, terminate on that basis, because that would have really, I think, got you out of any sort of adverse action risk.
Do you know, did the judge, I haven't read it, did he actually use the term smart ass?
Yep, smart ass. And something else as well. Some other term that was used.
The situation where the other person has worked with the manager for many years and had a good working relationship. But due to changes, there's been a realisation that the manager isn't as good as he thought what he was, and there was a bit of lack of respect in that. Well, hang on, and because of the changes, not only does the working relationship break down, but the actual manager starts to distance himself because his confidence is starting to go, and not have meetings and not have, and they go, well, you know, well, I won't let you know, I'll just make decisions and use my initiative to get on with the job. And then he becomes, hang on a sec, I'm being bullied.
Yes.
Because I'm being, you know, yet he's not doing the job.
And you do see that a lot. People, not that exact scenario, but someone's unhappy with the performance and then they think, oh, it'll improve, I'll just leave it, and it's sort of 2 years down the track, and they're suddenly telling them, oh, your performance isn't so great, and they're saying, well, I'm being bullied.
But the junior
Yes.
manager is doing really
Yeah.
well, but lost confidence. But the older, the more senior person is withdrawing.
Yes.
Yes. And then it's trying to work with that particular, because they do have want to be retained.
Yes.
That help them, because the mediation wouldn't work because the confidence level is down, and you know it's not going to be. Yet he's not doing what he should have been doing anyway. So.
And having, I mean, sometimes with those, remembering that like management is a skill that people do need help with, maybe even just giving some assistance in terms of not so much a mediation of the relationship, but doing things to try and build that person's management skills up.
And also remembering not everyone is suitable to being a manager, and you know, you might have been in a situation where they thought they were really good, but maybe they shouldn't be in that role. Maybe there's a, you know, competence issue, and that does happen a lot where, you know, you think someone's really good at their role and therefore they get promoted to be manager, but they just don't have those skills to manage people.
well, there's different types of management. Some of us work very inspirational managers who can work really effectively, particularly with a good team, and then if they've got more challenging employees, it falls apart. Actually, it's good that we should talk about this because this is, we're going through, but that when you've got one employee or both that have a diagnosed mental health issue, it just ups the stakes so much.
I mean, the question I commonly get is, should it even be investigated? I think in this scenario from memory, the manager knows that the person has a mental illness and someone else has complained about their behaviour, so they don't necessarily know. So I think you still need to investigate regardless of that, and you can't sort of think, oh gosh, this is going to be really difficult, or I'll just leave it alone and hopefully it'll go away. In this case, I think it was sort of swearing and erratic behaviour or something like that, where, you know, the other employee could put in a bullying complaint if you do nothing about it. You could end up with them off on workers' comp or something like that. So you really want to handle it, although you are probably going to handle it a little bit differently to how you might handle another investigation.
Employee assistance.
So you're going to need to tailor exactly.
Is so important.
Exactly.
You know, like a straight conduct, like you can go there, like you wouldn't with the person that's there. But would you just treat it straight as a conduct? So you
Look, I think if the person admitted straight away and said, oh yes, I have done it, but it's going to depend on what they say. You know, I see situations where people suddenly bring up for the first time a mental health issue, or there's been some knowledge and they're saying, oh no, it has nothing to do with that. So it often ends up being quite messy and complex, and you do need to deal with it a little bit more fully.
If they've raised, or you know, not just because you suspect, but if they've raised, or in the past said, you know, I suffer from bipolar, or whatever it would be, I think you really have to go there. You have to be very supportive, because you need to get medical information. You can't make assumptions. You have to. Actually, the really hard one can be when you suspect that there's a mental health issue, but they're not going there. And that's when they're not telling you anything. Then you just have to treat it as straight conduct, and that is very difficult. But
I mean, there was a case a few years ago, and I think employers also have, you know, a tendency to jump to conclusions when they find out an employee does have some sort of medical condition. This particular case, the employee had been sending weird and disturbing emails to colleagues, and complaints had been made, and they were apparently so weird they weren't actually reproduced in the judgment, so I can't tell you what was said.
otherwise they'd be on slides.
But the employer asked, well, are you willing to go off for a psychiatric assessment? And the employee agreed. The assessment came back from the psychologist, and he found the employee had schizophrenia, and had been undiagnosed, so the employee wasn't on any medication, wasn't under any treatment. 2 days later, the employee turned around and terminated. Quite an unfortunate situation, because the employee then brought unfair dismissal claim. And what was quite, I mean, it was very poorly handled. The employee eventually won their job back. They got reinstated. They got compensation for the pay that they'd lost whilst they were out of work. But what was important was the commission found that, yeah, okay, he's been reinstated, but that doesn't mean that he has to return to work immediately. You have to go away and make sure he's fit to return to work. You have to get clearance from his now treating psychologist saying, you know, he's fit to come back to work. So, I mean, it's important not to, you know, or they've got a condition, we don't need them, you know.
Or the other way, they've got a condition, we're just hands off because we're worried about a discrimination complaint or something like that.
But you have to be careful about making the employee aware that the manager may have a mental health issue.
You should, yeah.
Not to make them aware.
If they don't,
I'm very confidential.
it's
Yeah,
completely
unless
confidential.
that person gave their consent that was fine, you're not in a situation where you can go and tell the employee. So that does make it even more difficult, because you're sort of trying to handle this quite complex issue, and they're probably thinking, well, why haven't you done anything? I mean, I commonly at the end of investigations specifically say to people, you're not going to find out what happens to the other person. That doesn't mean nothing's not, you know, something's not happening, but you need to be aware that this is where the investigation ends. continue on and play out in front of you.
And so in that situation, you have to satisfy yourself with the help of expert medical information that the person can safely come back to work, so not continue to do whatever it is that they've done that's upset the other person. And so all you can say to the other person is, I'm satisfied that you're going to be safe in the workplace. You can't go any further than that. It is very difficult. And but I mean, obviously, in that really sad case that Alicia described, that's where obviously it sounds like the employer's just knee-jerked and thought, well, hasn't relied on medical information about what could happen if this person was properly medicated, or whatever it was, I haven't read the case, properly medicated and treated. They've just said schizophrenia will never be back in the workplace, and absolutely not the way to go.
They could have been stood down with pay on the basis that they'd seek medical advice, and when they got the medical clearance, they could come back to work.
Absolutely. Exactly, and that's what they should have done.
Yeah.
And even if, like, it's a small business and the person runs out of sick leave and it's not workers' comp, they can still be on unpaid leave. But terminating their employment is it's drastic. You can't really do that unless you're convinced. Exactly, unless you're convinced on medical information that the person's never going to be able to safely return to work, or within a reasonable period of time. Obviously, but 2 days is not a reasonable period of time.
That's right. So having a clause in the contract that we're in absence for more than 3 months could be a situation.
Maybe if they put in a workers' comp claim, though.
Oh, sure.
But 3 months doesn't get you over the Disability Discrimination Act, and there's specific cases about it. So 3 months, it depends on the size of the workplace, because it's got to be whether it puts unjustifiable hardship on the employer. So if you're looking at 3 months and the workplace is a small workplace and it's hard to get a replacement, if you're talking about, Westpac, they might say, actually, 12 months, so.
Oh, yeah, no,